She is. You do.
You ready?
How far is on?
All right, court continues the record. Court calls 20 CR 1866, People versus Stephen Pankey, who appears today with Mr. Viors, Mr. Rourke, Mr. Miller, and Ms. Wells appear on behalf of the people with respect to the Victims' Rights Act.
Your Honor, the Matthews family is still present in court. They chose not to go home yet. We have explained to them briefly what the purpose of today's hearing is and the request that Mr. Viors made last week to address bond. At this point, they do not wish to address the court. We are in compliance with the legislation.
Thank you. So I don't know, counsel, which one you want to address first.
What are the choices, Your Honor?
Well, reset for trial, and then address bond, or address bond and reset for trial.
Bond, please.
Very well. With respect to bond?
Thank you, Your Honor. The court sat through this trial, so the court is aware that certainly there is exculpatory evidence in this matter. The court is aware that the jury was not able to reach a unanimous decision, based in part on the volume of exculpatory evidence. I would, based on the fact that there was a mistrial in this matter, I think that merits some reconsideration of the bond situation. I would ask this court to, at the very least, to allow Mr. Pankey to post a bond through a surety at the amount that's currently set, or to significantly reduce the amount that's currently set. It's currently at $5 million cash only. I would ask the court to, reduce the court is going to keep it at cash only, to reduce it significantly, or to allow Mr. Pankey to post the bond through a bondsman. Thank you.
Thank you. Mr. Miller?
Thank you, Judge. Your Honor, the court sat through nearly 20 days of trial. The court found on 2 separate occasions that a reasonable juror could find the defendant guilty beyond a reasonable doubt of the crimes as charged. But I think more importantly, Your Honor, we've been in touch with the defendant's ex-wife, Angela Hicks, and it's people's position and her position that she's in grave danger after her testimony in court if he is to make bond or be released. She knows his history that I outlined in the initial bond hearing in this case. And I'm also speaking on behalf of the Matthews family. They object to any bond change or reduction in this case. The court knows a little bit about the whole Debbie Moon case that kind of came up peripherally. We did not have extensive hearings on it, but Debbie Moon has a friend, and also Debbie Moon herself said the defendant stalked her until she dropped charges. In 1977, it was a lot different than it is now. So he stalked her until she told the DA she didn't want to pursue the sex assault allegation. We also have reports from numerous family members that he would continually stalk them and harass them, call him numerous times when he thought they did him wrong, whether it be the purchase of the house at 6086 the court heard a lot of testimony about, or some other slight he felt the family had done. I also think I told the court about a time when the defendant showed up at the presiding judge's house in a case he was a civil litigant in, and threatening that person. I think in light of the serious nature of the charges, in light of all the information this court has heard, that the bond should remain the same, especially with his history of stalking and harassment of witnesses in this case.
Thank you, Mr. Miller. I appreciate and understand both arguments. Frankly, I don't believe that there's been any circumstance that has altered the court's justification or concerns or logic when the court originally posted the bond. I don't believe it's appropriate, or I'm not inclined to go into all those factors right now. I think I want to make sure that to the extent we have publicity, that the court is circumspect with respect to what I highlight, but we've had significant litigation regarding behaviors and concerns, additional testimony at the trial regarding certain behaviors that corroborate those concerns. So at this point, the court is not going to modify bond. The court will retain the bond as set, including the conditions of bond. So with that, counsel, is your request to reset this matter?
Judge, it is going to be our request to extend this case to trial. However, I know Mr. Jurors has another matter that he needs to address with the court before we do that.
Very well. Mr. Yorst?
Thank you, Your Honor. Your Honor, I am at this time requesting leave to withdraw as Mr. Pankey's counsel. It has been a pleasure to represent Mr. Pankey, but, given the nature of my small practice and, my relatively advanced age, I'm just not in a position to devote the time and energy necessary to retry this case again, or to try this case again, having spent the last month, in a very intense trial of this matter. I've spoken to Mr. Walsh, the Public Defender's Office, who's now seated behind me, and it's my understanding that because Mr. Pankey is in custody, that he qualifies for the Public Defender, and that the Public Defender's Office is actually, at this moment, prepared to enter their appearance.
Let me ask, have you discussed this with Mr. Pankey?
I have.
Do you have his consent?
I do.
Okay. And let me just confirm for the record, Mr. Pankey, that as it relates to counsel of choice, is it your decision to allow Mr. Viors to withdraw as your counsel?
It was my understanding he was going to withdraw at next hearing, but I guess I agreed to release him with my thanks. He did a great job for me and he fought hard. Thank you.
Very well, thank you. Call then allow substitution of counsel, allow Mr. Viors to be withdrawn. Court will appoint the Public Defender's Office. Ms. Devereaux, Mr. Walsh appear on behalf of Mr. Pankey.
Aye.
And Mr. Walsh.
Your Honor, given the appointment, if the court could give us just a brief moment to speak with Mr. Pankey about where to go from here.
Kind of.
Your Honor, given the state of the proceedings, my request to the court is that the court allow Mr. Pankey to toll his speedy trial rights for at least a couple of days here. We need to chat with him at the jail about what to do from here. I do understand that the discovery is quite voluminous in the case. And so we'll have a discussion about whether, in our view, this ought to be set within 90 days. But my request at present would be to set a relatively quick set over, have us come back and advise the court about our position on that issue.
Any objection?
I don't have an objection, Judge. For Mr. Walsh and Ms. Devereaux's benefit, there's roughly 24,000 pages of discovery. There's about 425 audio recordings. There's 22 days worth of trial transcripts, which had been ordered. I emailed with court reporter last week that we don't need them within 10 days, but obviously to say that it's voluminous would be an understatement. So I don't have a problem with at least a couple of days for them to discuss where we go from here.
Well, it won't be this week. We're in trial. I think counsel's aware of the circumstances. Necessitating this court substituting in on a first-degree murder case, and there's some time constraints for the jurors, so I don't want to take up any of that time this week for those reasons. Start another trial next week, but if we went perhaps midweek, I don't know, we have Wednesday or Thursday, 1:15? Don't know. Thought so. So about Wednesday, 1:15, is that available? Yes. How about the 17th at 1:15?
Judge, can we have just a moment to confer with the Matthews?
Certainly.
please? Judge, the 17th at 1:15 is fine with us as well as the Matthews family.
Thank you. Mr. Walsh, does that work for you as well?
It'll work fine, Your Honor. And just to be clear, I don't anticipate addressing the substance of the proceedings on that day, but rather a discussion of when and if the trial should be reset.
Right.
Obviously, we're investigating, given the extensive media coverage in the case, whether this is the correct county to try the case as well.
Very well. Then we will set it for status and setting. Speedy trial rights will toll till at least November 17th.
I'm sorry.
Go ahead, Mr.
The only request I have is to confirm that that's the defendant's wish. I know that Mr. Walsh indicated that, but I just want to make sure that the record's clear that the defendant is agreeing to toll his speedy trial rights until the 17th.
Mr. Pankey.
Your Honor, it's my understanding that I'm not giving up speedy trial, I'm just delaying it until this next hearing, is that correct?
That's correct.
I agree to toll it, Your Honor.
Very well.
Thank you.
Thank you. And anything else we can address then today on behalf of the people?
No, sir.
Mr. Walsh?
No, Your Honor.
Very well. Matter will continue then to the 17th at 1:15. All right, thank you. Court will be in recess.